Case number 115457, State of Kansas v. Kurt Powell.
May it please the Court, Assistant District Attorney Leslie Isherwood appearing on behalf of the State of Kansas. Your Honor, I would like to request 3 minutes rebuttal time if I may.
3 minutes is granted.
The state has asked this court to review the Court of Appeals decision in this case as a result of the reversal of defendant's statutorily mandated Jessica's Law sentence. The reversal was the product of the Court of Appeals' conclusion that the district court employed the wrong procedure when it considered the defendant's request for a durational departure in this case. The standard of review for this court, it's a matter of statutory interpretation, so this court conducts de novo review. The law in effect at the time that the defendant was sentenced indicated that the sentencing court was to impose the statutorily mandated lowest minimum term unless, following a review of the mitigating circumstances, the court concluded that there were substantial and compelling reasons to depart. Here, the defendant filed a departure motion setting forth 5 proffered mitigators: his lack of criminal history, the availability of rehabilitative measures, his willingness to participate in those programs, his strong work history and family support, and the fact that he cooperated with law enforcement during the course of the investigation. During the hearing, the defendant presented the testimony of Dr. Barnett to support his departure motion, and Dr. Barnett advised the court that as a result of his clinical interview, he had concluded that the defendant was not a compulsive child molester and that the odds were long that he would reoffend. On cross-examination, however, Dr. Barnett acknowledged that he was not aware that the defendant had previously abused a young woman in much the same manner as he had abused the victim in this case, and the state then called that victim, ML, to testify to substantiate its assertions. In ruling on the defendant's motion, the district court reviewed the mitigating factors that had been proffered, the fact that substantial and compelling reasons were required in order to depart. The court then defined what constitutes substantial and compelling, and then simply stated that as a result of all the evidence that it had reviewed, there were not substantial and compelling reasons to warrant a departure, and that the statutorily mandated sentence was a just one in this case. The Court of Appeals, however, found that reversal was required because it could not definitively determine whether the district court had improperly weighed aggravating circumstances against mitigating circumstances when it was ruling on the defendant's departure motion.
Have we ever ruled that has to be explicit, that the judge says, I am not weighing? We've never said that, have we?
No, there has never been a requirement of any sort of special indication.
Explicit statement.
Yes.
And do we, in your view, Ms. Isherwood, do we need to overrule Jolly in order to hold for you?
No, I don't believe so. I think Jolly, we're not here to demonize Jolly. I think...
but to praise it.
Part of it. I think Jolly told us 2 separate things. Jolly first told us that the court is not permitted to consider aggravating factors against mitigating factors when determining whether a departure should be granted. Then Jolly also told us that the sentencing judge is to consider all information that reasonably might bear on the proper sentence given the crime committed. The second portion is accurate, but that accuracy has been surpassed by some confusion regarding the aggravating and mitigating circumstances statement. Specifically, a plain reading of the statute makes no mention of aggravating factors. And in the departure arena, an aggravator is statutorily defined as specifically as a substantial and compelling reason that enables the district court to go beyond the standard range as for sentencing. And as this court has recognized, when a defendant comes before the court convicted of a Jessica's Law crime, he's already sitting on the most severe sentence. So truly the only way for that term to be modified is to go downward.
Counselor, I didn't understand your plain reading argument. Aggravators aren't mentioned in this specific statute.
That's what I said. A plain reading of
And
statute.
you seem to be saying, because it doesn't explicitly say don't consider aggravators, that we're reading something into it. And I think you're weighing something into it when you say the judge can consider. Because specifically, it said where the judge finds substantial and compelling reasons following a review of mitigating circumstances.
Correct.
And so aggravators aren't even mentioned. So why is it reading something into the statute for us to say you're not supposed to consider aggravators when you do that specific function that's laid out in the statute?
Well, my issue was the fact that Jolly specifically says that the plain language says you cannot consider aggravators when the plain language does not say you can't consider aggravators. What the statute says is that the court has to consider whether there are mitigating factors.
It's just silent on aggravators, is what you're saying.
It's silent on aggravators, and aggravators speaks to going beyond.
Beyond the norm. Here's my question. It seems to me that when a defendant advances a mitigator of no criminal history, the state has to be entitled to put on evidence that whether or not he got caught and prosecuted, there was similar previous criminal behavior.
And I would agree. And I think part of what's happening here is when the state is presenting that rebuttal evidence, it's been classified as an aggravator or an aggravating circumstance. And it's simply not. The state would say it detracts from the quality of the evidence that's being presented by the defendant, but it is not an aggravator.
Has a tendency to disprove the evidence advanced by the defense,
Yes.
which is about mitigators, whether
Yes.
the mitigator is demonstrated, which is the defendant's burden.
Well, and to me, there are two parts to this equation. The court first has to determine whether there is a mitigator. What has happened with the departure motion is a proffer, but that is not a per se mitigator. So the court first has to make that determination. The second determination is once that mitigator is established, does it rise to the level of a substantial and compelling reason to depart? The push that we're experiencing here, the evidentiary battle, is at that first stage, whether this even qualifies as a mitigating circumstance. Now, the Jessica's law structure was specifically put in place in order to impose severe punishments on those that victimize some of the most vulnerable members of our society. What is evolving in the wake of Jolly is some sort of perception of a single-sided sentencing structure that the state should have to sit idly by while this evidence is presented by the defendant without the opportunity for the state to rebut that. And how that would operate here, Dr. Barnett testified that he was not a compulsive child molester and the odds were long that he would reoffend, when in actuality that was not an accurate or correct statement. But if the state is not permitted to rebut that, then the court cannot exercise its best judgment in determining whether this is a mitigator, to then go on to qualify whether it's a substantial and compelling reason.
In essence, what you're doing here is rebutting the mitigator with an aggravator, though, in this particular instance. Because isn't it really an aggravator when you show that there's this kind of repeat offenses against uncharged behavior?
Again, I very much hesitate to use the term aggravator.
I know
To
you
me,
do, but wouldn't that be an aggravator in a typical instance that you could, if you showed that?
I think it maintains the status quo. It maintains the status quo that the statutory mandated sentence is what's just in this case.
Why
And
isn't that just part of the totality of the circumstances?
It is. And it goes directly in line with what the legislature has said as far as the construction of our sentencing
And so
provisions.
even
Exactly.
if, I know your position is this is not the case we have in front of us right now, but even if we assume, and there are cases like this, that there are mitigating factors that are proven up and the state doesn't even contest their existence,
Such as criminal history.
shouldn't the court still be permitted to consider the totality of the circumstances, which might include even the specific facts of the crime and the manner in which it was perpetrated.
Absolutely.
And my reading of Jolly suggests that that's not permitted.
I think Jolly has some internal conflict because Jolly also says that the court is to consider all evidence. Now, the general construction provisions of our sentencing structure indicate that they're to be liberally construed and that persons convicted of crime shall be dealt with in accordance with their individual characteristics, circumstances, needs, and potentialities as revealed by case studies, and that dangerous offenders shall be correctively treated in custody. Taking that in conjunction with the departure provision under 2168.15, it provides that in determining whether mitigating circumstances exist, the district court shall consider any evidence that's been presented at the proceeding, the PSI, the written briefs and oral arguments of the parties, and any other evidence relevant to such mitigating circumstances that the court finds trustworthy and reliable. It's the state's position that these inclusive sentencing provisions in the sentencing structure as a whole are being lost with this concept of aggravating factors and aggravating circumstances. An accurate assessment simply cannot be completed in the absence of all relevant evidence.
So we just wipe out the word aggravator anytime we talk about Jessica's Law? Is that your suggestion?
I don't think that aggravator has a place
Place
in the
in-
Jessica's Law realm, simply
So-
because of how that's been defined.
So even though it might be an aggravator in another circumstance, we don't consider it that here.
I would say it, yes, I would say it maintains the status quo. What the state offers to rebut the defendant's proffer of a mitigator maintains whether that statutorily mandated sentence is what's required in this case. For example, here, the defendant had requested a departure down to 2.5 years, from 25 years to 2.5 years. And what he presented in support of that motion was the report and the testimony of a doctor who had no awareness of the fact that he had abused another young woman in much the same way as he had abused the victim in this case. It cannot be the intent of the legislature that the state is required to sit idly by in these circumstances while the defendant is permitted to present his evidence, and that is not subject to rebuttal. The state would respectfully request clarification from this court on exactly how the procedure utilized during Jessica's Law sentencing can be aligned with the intent of the legislature, and in so doing, we would ask that the Court of Appeals decision reversing the defendant's sentence and remanding the case back down to the district court be reversed, and the decision of the district court and the defendant's sentence be affirmed.
Don't you
Counsel,
see
what-
it? Excuse me.
Go ahead.
Go ahead.
Jolly was decided in 2015. Do we make anything of the fact that the legislature has not changed that statute in light of Jolly?
Because I think Jolly has some positive points, and I don't think Jolly completely runs afoul of the statute because it says that the court can consider all evidence related to a proper sentence. So I don't think that it necessarily warranted a change of the statute.
And you also said that it says aggravators, don't label anything an aggravator at least. And Jolly said that. Aggravators have no place in Jessica's Law sentencing. I think I wrote that down. That's what you said a moment ago.
Jolly did not say that. Those were my words.
Okay, all right. Thank you.
Justice Johnson, you had a question?
Do you see a distinction between rebutting the mitigator and weighing against the mitigator? In other words, here the defense puts on a witness to say, hey, we have a mitigator here, and that witness is going to testify. The state obviously should be able to say, nuh-uh, that's not true, and here we have a witness that will rebut your witness. But that's different than saying, this guy did all these other bad things other times, not as a rebuttal, but just say, well, those mitigators don't carry the day because we have aggravators out here, that are unrelated, that should negate those mitigators.
Well, first of all, I don't think it's unrelated because the court can consider anything related to the defendant's specific characteristics. So I think it's necessarily related to the case. But as far as weighing against a mitigator, these aren't mitigators simply because they have been included in the defendant's motion. He does not come to the court with per se mitigators. The district court first has to establish whether they are properly classified as mitigators, and in so doing has to have all relevant evidence available to make that decision. So in that respect, it is not an aggravator, it is just a portion of the body of evidence that the court uses to make
I
that
understand
determination.
that. I think we all got that point, and I don't think anyone's challenging the state's right to rebut defendant's claim of
Well-
a mitigator. But what I'm saying is that if the state is arguing this not as a rebuttal of Dr. Barnett, but of some other basis, that he's just a bad person, and they made arguments, well, gosh, he did this to his own daughter, and that sort of thing, that the victim was his own daughter, and that kind of thing. That's a little different, isn't it?
Well, first of all, I want to backstep a little bit. I know that it's going outside the parameters of this case, but part of the reason it's so important to have this case before the court today is that there are some district courts that are taking the position that they believe that the state does not have the position to rebut it. So I think that is one primary concern I would like to point out. But again, it is part of the larger body of evidence. I don't think it rises to the level of an aggravator simply because the defendant has not.
But counsel, sorry to just interrupt you, but as I understand at least the heart of Justice Johnson's question, when you've got a mitigator that's proven up on one hand, we're not talking about disputing the evidence, it's
Right.
proven up, and you've got the totality of the case on the other hand. It is a balancing, right? That is what the state is asking the court to do, is to weigh these things against each other. I guess I'm in sympathy with what I heard Justice Johnson asking, that appears to me to be a balancing.
I think the court just takes every piece of evidence that it has to determine whether that mitigator even exists.
That prompts a question from me, and I wasn't going to ask any, but the questions from Justice Johnson and Justice Stiegel are a different case than this case, it seems to me, because the court didn't say it was weighing anything. All this court said was, I've considered everything you guys put into evidence today, and here's my decision. And so regardless of whether it would be the worst thing on earth if the court weighed some evidence against a mitigator, all this judge did was say, I've considered everything I got in front of me, and here's my ruling. And that's important to me because we start these cases with the premise from the statute that the district court doesn't have to explain its denial of a departure motion. It only has to explain if it grants a departure, correct?
Yes.
And so where the court gets in trouble is when it opens its mouth after saying no.
Some cases say that, yeah.
And, well, I mean,
Yes.
now we're picking apart what's going on.
Right.
And so some judges have, in these cases, have gone to, tried to explain why they're doing what they're doing, and
Right.
then they get up on appeal and people have started to pick it apart. That's fine. This judge, though, only said, I'm considering everything you guys put into evidence today. And that defendant, in this case, didn't object to the evidence that we're all worried about. So, your mission here today is to get us to narrow or repeal,
Clarify.
reverse Jolly. So we're going to call it clarify. So within the parameters of this case, these facts, which is all the judge did was say, I'm going to consider everything you put on, which we would hope judges would do. How do we narrow Jolly? What is it that we say that begins to constrict the problems that you're seeing? You see what I'm saying?
I think I do. I think that the portion of Jolly that speaks to the weighing of the aggravators and the mitigators needs to either be eliminated or it needs to be refined, because there simply aren't aggravators in this context. And so when you say that the court's not allowed to weigh aggravators against mitigators, you're then putting this additional burden on the district court to provide some sort of incantation or some sort of
But this
rubric
judge didn't do
uses-
that.
No, he didn't. Well, you asked me what should we do with Jolly, and that's what I think needs
okay.
to happen.
Even though this judge didn't do that, my problem is personally, I'm wrestling with how much narrowing we can do when the facts presented are this sparse.
Because I think what the judge did was in line with what was accurately stated in Jolly, which was to consider all the evidence. That part of Jolly is clear, and that part of Jolly is in line with all of the sentencing provisions that we have. So in this case, it didn't run afoul of Jolly. It's the Court of Appeals that found that it did by not announcing what it did with the aggravating and the mitigating circumstances. But when you don't have the aggravating and mitigating circumstances, that doesn't even have a place here. So that's the first problem.
But is that as far as we can go, given the facts of this case? I guess you're helping me articulate it. But so here the Court of Appeals said, you've got to say you didn't weigh, apparently.
Which you don't have to do, and I think that can
So
be
if we just say,
clarified.
no, that's wrong, we still haven't solved these other problems that you're saying come from Jolly, and I'm trying to figure out if we just put up our elbows and try to solve some problems, or if we say we're solving this problem and wait for the next one to keep narrowing, if that's what we decide to do.
I think if the portion of Jolly is highlighted that simply says that the court is permitted or is required to consider all the evidence that pertains to a reasonable sentence in connection with the defendant's specific particularities, that is the part that needs to be preserved. The aggravating and weighing of circumstances part is where the confusion is coming in. It doesn't have a place in a Jessica's Law realm, nor does it need to be specifically articulated. So somewhere between those two is where that refinement needs to occur.
Thank you, counsel.
Good morning, Your Honors. Corinne Gunning of the Appellate Defender Office, appearing on behalf of Kurt Powell. I would like to begin just stating that the facts of the case, to clarify something with the facts of the case, is that Mr. Powell in this case pled to the strict elements of a single offense, indicating the victim's initials and her relationship to the defendant. No additional facts were admitted, and it was part of the plea, other crimes were dismissed, other charges were dismissed.
And first offense?
It's his first offense, yes.
He pled to first offense.
Yes, which is why, when he requested, the state pointed out, it's 2.5 years, he was a criminal history I, which is where Jessica's Law, the departure would put him on the grid at an I, and he asked for the statutorily allowed half of that amount. And so in this case, I would ask that this court reaffirm the majority opinion in this case from the Court of Appeals based on this court's opinion in Jolly, and reaffirm Jolly as well.
So you're saying that when the defense puts on Dr. Barnett, he gives an opinion. That opinion wasn't based on all of the facts vis-a-vis your client. He admitted he didn't have knowledge of prior sexual abuse, that the state is not allowed to challenge that incomplete or inaccurate or that opinion based on incomplete or inaccurate data? You're saying they don't have any right to challenge that?
I would not go that far. I would argue that the state does have the opportunity to say, well, which they did in cross-examination. Dr. Barnett, are you aware, during the course of this investigation, he admitted to abusing a former stepdaughter of his. Dr. Barnett, no, I was not aware. Yes, that probably would factor into my analysis of whether or not, but I can't say what conclusion I would reach otherwise. Problem is then putting on that former victim and having her testify to everything that would have arguably been 6455 evidence, but was not related to this case at all. And so I think having her testify, well, I was abused for 20 years, goes beyond simply rebutting the evidence to say, well, your conclusion is not really taking into consideration everything.
It may go beyond it, but it went directly to whether there was criminal history. It went directly to whether his mitigator was accurate.
And from my perspective, I suppose you guys might not think there's a difference between cross-examination being enough. I think having her then go further and explain all the details of the abuse without really, that's trial evidence without being subject to a trial. And so I think that from my perspective, as I argued in my brief, is evidence the court shouldn't have considered because it's not a fact of the case.
Why isn't it characteristic of the defendant? Why doesn't it go to that question of the bottom line of Dr. Barnett's opinion that he would not reoffend? It was not doesn't it show that he had the characteristics of having offended more than once?
It's, again, I think that his admitting that during the investigation and that fact that came out during cross-examination, I think that's sufficient to prove whatever that is, that perhaps there's another victim out there. But I think when you have that alleged victim come in and give this testimony that is not determined by a fact finder to be truly credible, and that she's just giving this evidence, that I don't believe that has really the same place in a sentencing hearing generally. I don't think in other cases we allow that type of evidence to come in, and I don't think that kind of should have come in here.
I don't understand that, because the state in cross-examination can't cross-examine based on its imagination. It has to cross-examine based on evidence. And here they had to put on evidence under oath, which is this other victim. So it isn't enough just straight away, it's not enough for the state to try to cross-examine based upon its notion that there's another victim out there. It has to prove it, doesn't it?
Well, and I think that it's
So if it has to, the answer to that has to be yes. The state has to have evidence to base a cross-examination on. You've got to accept that proposition. And so once you're there, then you've got to put on the victim's testimony to establish it under oath and to give the defendant an opportunity to cross-examine her and challenge her credibility, right? The final point of that is, did the defendant object to her testimony coming in?
no.
So if the defendant doesn't object and you've got this other rationale, why can't the court then consider that testimony in the denial? That's the problem we have to wrestle with here. The Court of Appeals said, for whatever reason, this judge can't just say, I considered everything that y'all put on without objection.
Right.
And so how do, with those facts, how do we agree with the Court of Appeals majority?
Well, I will, I'm going to stand by, I think that the evidence considered also arguments of counsel as well, in addition to the testimony of this young woman, that, well, we put on our evidence and they've put on these statements of somebody and that's not really enough, they didn't testify. I think there's more going on here, but I
Well,
will.
let's look at the arguments. I pulled up the sentencing transcript and looked at how the state argued stepdaughter's testimony, and it looks like they were using it directly to rebut Dr. Barnett. They explained about why that made his testimony not credible, and went into the fact that I don't care if there's other convictions, if there are other victims out there of the same abuse, that's what we need to protect society against. And so it looks like to me that the state, at least in their argument, was using this as a rebuttal rather than some other unrelated aggravator. Did I read the arguments wrong?
I think that I'll start with, I think that Jolly probably could use some clarification. I will agree with the state on that. Just based on the number of cases that we are getting in our office where there's so much confusion at the district court level. But I think that where a lot of the confusion is happening is, well, what is a mitigator? What's a proper rebuttal to a mitigator? What's an aggravator? And what's a proper fact of the case to be considered? Because to speak to Justice Stiegel's point, I think that Jolly does say, consider the facts of the case along the mitigating circumstances. But I think there has to be some sort of limitation to the rebuttal, because the way that the state was arguing is he's this horrible sexual predator with this evidence that wasn't really part of the case, and wasn't really, I can see that I'm not winning the argument here on this rebuttal. I don't think that many of you particularly agree with my characterization of the evidence, but I think that having her come and testify just about how horrible of a person is that he's been testifying, he's been abusing her for 20 years, I think that goes more than just a mere rebuttal of Dr. Barnett's conclusions. And I think that the evidence that he admitted to having committed this abuse, that is sufficient, not just.
Dr. Barnett testified he couldn't imagine a better candidate for a departure sentence. That was part of the mitigating or evidence of mitigators, right?
Yes, and that's related to he's a candidate, a good candidate for treatment. He's open and willing to commit to going through treatment, recognizing he has a problem, and that he believes that he's not a candidate to reoffend significantly. And so I think that it probably goes more to that likely to reoffend, and as others have pointed out, that maybe the criminal history, but there's many facets to Dr. Barnett's conclusions.
Why is the judge here not entitled to hear from this victim as it relates to undermining the opinion of Dr. Barnett, and whether or not your client has little, if any, chance of reoffending? Is the judge not entitled to hear, I guess, how serious that abuse was?
I think that it goes outside of what the court is supposed to view, what evidence is supposed to come into sentencing, the court in Jolly says, consider all the reports, the defendant's background, the facts of the case, and public safety. I guess it might go to the question of public safety, but my big problem, and I think this comes up in other cases, one of the cases is Pulley is cited, is that this is uncharged conduct, maybe in a different case, but it's uncharged conduct that has not been proven or admitted to, that is coming in for the first time at sentencing.
Except here, the way the attack, at least initially, started with Dr. Barnett is, did you read the probable cause affidavit? And in that included the allegations of the stepdaughter, to which he admitted. And so it's not totally unrelated to this case. I understand your concern if it's something totally outside the case, never mentioned and suddenly brought in at sentencing. But here, the way it was framed was, did you even read the affidavit that led to the charges here? Because it included this information. So isn't, at least here, I would just think that would be fair game. It goes, it's not as broad as what you're kind of speculating or kind of alluding to in a different kind of case where something happened 10 years ago and is suddenly brought in at sentencing.
Well, I just, this goes to a larger question I have is, I think that there's, possibly a case on the summer calendar of this docket, as well as, the Pulley case that I noted is, and in this case, Mr. Powell was charged with multiple counts of the same charge. 2 of those were dismissed by the state and 1 stayed. Well, then the question, if we can consider facts that are not really related to this case and the actual factual underpinnings of that, then, I don't want to open the door.
So here, even though it's a part of the affidavit and the expert didn't look at that, getting into it here because it's not a part of what he pled to would be outside the bounds in your mind.
I think that it goes beyond simply rebutting the statements of Dr. Barnett, because the other thing is, the state could argue and has argued in other cases. Well, he didn't just abuse her once in this case. I mean, we've got a long history of abuse of the victim in this case, and why, I don't want to. I hesitate to bring up this argument because I don't want to expand the considerations, but if the court should not be considering the fact that he pled to 1 count, but he actually may have committed multiple counts because that's what the probable cause affidavit says. If the court's looking at the probable cause affidavit and saying, well, you didn't just abuse her once, you abused her multiple times, and that's definitely, those mitigators are no good, I think that that's going outside of what the court should be considering. The very fact of 1 count in this case gives him a presumed sentence of 25 years, at which time he's eligible for parole, but it's a life sentence on that 1 count. And so then if you're adding in all these other things, I think that just adds, it effectively acts as an aggravator, and which is where I think that courts are.
Isn't that the problem? Aren't we using aggravator in an imprecise way, different than what the statute uses it? And maybe that's part of the confusion about Jolly, in that here we're not really talking about things that would aggravate and cause a higher sentence. We're just talking about what might be egregious facts or things that are very negative towards the defendant. So they do aggravate in the common sense of the word, the situation, but they're not an aggravator in terms of the legal sense of how it's used in the Sentencing Guidelines Act.
Yes, and I do think that is correct. And, this statute that we're looking at does not reference the aggravators as clear. And it doesn't even reference back to how we handle this in the guidelines.
And isn't that usually where we weigh, is when we weigh whether the aggravators would outweigh the mitigators? But we're not doing that kind of weighing here. And isn't that all Jolly says, is that's not the sentencing network we have here? But we can weigh the evidence, again, in a common way that you determine weighing evidence to look at credibility or any of those kinds of things. But we're not weighing aggravators against mitigators.
And that's where as I think I've mentioned, is that's where I think the confusion for courts is coming in, is what is a proper rebuttal to a mitigator, what counts as an aggravating fact, and then what is a fact of the case. And a lot of what I argued in my brief in this case is that some of the evidence that was presented and considered by the court in this case is not a fact of the case that should have been considered. That her testimony may be an egregious fact, but it's not a fact of the case. And the fact that he was charged with 3 counts, if the court can consider, again, I hesitate to open up to you guys ruling that the court can consider, well, we dismissed 2 counts, but the court can consider he was actually charged with a lot more than he he pled to, because then I don't know what incentive anybody has to plead if we're going to consider everything anyway. And so I think that this evidence is treated as an aggravator and is within the facts of the case, because I do think Jolly correctly says that you can weigh the facts of the case against the mitigating facts. And most of the facts, mitigating facts in this case are statutory or are recognized by courts as proper mitigating facts. So I don't think proving that they are actual mitigators is the problem. It's just how are we considering that with the evidence that's put on, and I don't think that the evidence was proper in this case. And I guess I see I'm out of time, so unless there are any other questions, I will.
Any more questions of counsel? All right, thank you, counsel. You reserve 3 minutes for rebuttal.
And I really, Your Honor, just have a single comment I'd like to make, and it's really just more confined to this case. So I just wanted to make sure that it was clear that the evidence regarding ML was not something that just came out at sentencing. It was the product of a 6455 motion. That motion was heard, and that motion was granted. So had the defendant remained on the trial track that he was originally on, that would have become actual submitted evidence. So it is, in fact, part of the nature of the case, excuse me. And as far as the plea agreement goes, there was a specific provision in the plea agreement that the defendant was agreeing that by entering a plea, he would not have contact with ML. So this was not a situation where the existence and the details surrounding ML were first presented at the time of sentencing. So it was, in fact, contemplated as part of the case as a whole. If there are no further questions from the court, we would simply just reiterate that we would request that the Court of Appeals decision be reversed and the defendant's sentence be affirmed.
And you agree that the no contact orders were not appropriate to be in the sentence? Yeah.
Any more questions? See none. Thank you, counsel.
Thank you very much.
Thank you both for your arguments this morning. Court will take this matter under advisement.